Hello again. My name is James Byrne, and I'm going to pick up from where we left off on the first episode of this special regarding the deeds, because there was much um, regarding the deeds that a lot of the polygamists and those historians believing in the polygamist narrative using these as means to prove Joseph Smith was allegedly involved in polygamy. But they're just false claims and miscued facts. And, the circumstances can be miscued. Um, so we're going to continue now with I'm going to share the screen here now and continue where we left off, where we discussed about the Maid of Iowa, which was a ship that was used to carry immigrant passengers up um, the Iowa River from St. Louis or somewhere. And let's go to the Joseph Smith papers there. Let's see. Joseph Smith papers, 14th of September 1844, Levi Moffat petitioned the Des Moines County Probate Court to become the administrator of Joseph Smith's estate in Iowa Territory. The same day, he initiated a replenishment suit on behalf of the estate to recover the Maid of Iowa steamboat from Charles Ross. Moffat had built the boat at Augusta, Iowa in 1842 in partnership with Dan Jones. June 1843, Joseph Smith purchased Moffat's interest in the boat for $1,375, given two promissory notes for the amount. Shortly thereafter, Joseph Smith transferred his interest to his wife, Emma Smith. However, under the common law doctrine of coverture, the boat remained his personal property. Joseph Smith purchased Jones' interest in the boat, making him the sole owner. The next month, he and Emma transferred the Maid of Iowa to Joseph Smith as trustee and trust to the church, making the boat the church's property. On the 15th of June 1844, Joseph Smith leased the boat to Arthur Morrison and Mulgazi Calhoun. Somewhere before August 1844, Morrison hired Ross to pilot the boat. After Joseph Smith's death, the boat entered a period of contested ownership. Mid-August 1844, Emma Smith, acting on the advice of attorney James Woods, sought to claim the boat as a personal asset of Joseph Smith, along with other belongings to Joseph Smith as trustee in trust. However, William Clayton, acting on the orders of the recently elected church trustee Newell K. Whitney, the Apostle Brigham Young, refused to hand over the papers connected to the boat. Clayton, Whitney, and Young claimed that the boat was a church asset. Joseph Smith's estate proceedings should not interfere with the business of the trustee in trust. So it would seem to be then that it didn't, uh, it wasn't given to Emma Smith then. She never had it. So we'll now go on to History of the Church, Volume 4, chapter 24. The 12 met at Brigham's house, August 31st, 1841, for the purpose of taking into consideration the situation of the church, to attend to the business of the church, assist the trustee and trust in his arduous duties. Resolved unanimously that we deeply feel for our beloved President Joseph Smith, his father's family, on account of the great losses they have sustained in property by the unparalleled persecution in Missouri, as well as the other many persecutions they have sustained since the rise of the church, which have brought them to their present destitute situation. Therefore voted unanimously that we, for ourselves and the church we represent, approve the proceedings President Smith in making over certain properties to his wife, children, and friends for their support. And that was the August of 1841. So clearly, if property and things was given over to Emma and her children, it was as this situation uh, made mention of, because they were so having lost property in persecutions. So it was a deed for Julia Smith and others. And trustee in trust, Eliza M. Partridge, Emily D. Partridge, Carol M. Partridge, and all. So the Partridges were deeded the property also. History of the Church, Volume 4, resolved on account of the peculiar situation the church hitherto, it has been expedient and necessary that the deeds, bonds, properties of the church should be and have been taken and holden by communities of the church and private individuals, but that we now have a trustee in trust via President Joseph Smith, appointed according to the laws of the land. Wherefore voted unanimously that we advise the trustee in trust to gather up all deeds, bonds, properties belonging to the church, which we now held either by communities or individuals, and take the same in his own name as trustee in trust for the Church of Jesus Christ. Now we have the document showing the Nauvoo Registry of Deeds. This is the actual photograph of the actual book itself. And we're just going to show some entries from it here. It's not going past page 1, but that being the original registry. So we know exactly the trustees' land book from 1839 to 1842. And then there's a trustees' land book B from August 42 to December 1845. And that is actually in the Joseph Smith papers. There was another book written by Susan Easton Black, and she comprised the property transactions for 1839 to 1859, showing exactly the time period of Joseph Smith in Nauvoo all the transactions that would have taken place. We're now talking about Hiram and Mary Fielding had a deed. So a lot of these, the reason I'm telling about these is a lot of these transactions, they wanted to take it out of the name of a private individual, as in Joseph Smith, and put it into the trustee in trust so that all the deeds could be uh, um, transacted there as a church entity then, rather than a private individual. So Hiram, Mary Fielding, and Emma, they would have given over their deeds and property into the trustee of trust. Joseph Smith and Emma Smith deeded their property to Joseph Smith as trustee in trust. So that it would be under the protection and the law that's given to safeguard private individuals and as church property, as opposed to church property from private property. So, back again, I mentioned this just to demonstrate the necessity, the role of the trustee in trust, uh, that Joseph Smith giving over these properties to Emma, to Hiram, to other members of the church, not in a polygamous manner or to satisfy some polygamous wives, but as a um, part of the duties of the legal protections of trustee in trust. Now, around this time of 1837, there was a lot of bankruptcy because there was a lot of banks and all that went down, and in the Sangamo Journal, Joseph Smith's bankruptcy notice. In the matter of the petition of Joseph Smith, a bankrupt to be discharged from his debts, notice is hereby given to all creditors, others interested, of Joseph Smith, a bankrupt, to appear before the District Court of the United States, first day of October 1842, city of Springfield in District, Illinois, and show cause, if any, there have why the aforementioned Joseph Smith should not receive a final discharge from all his debts, and a certificate thereof be granted to him, dated Springfield, 17th of June, 1842, with all the creditors. The debts of Joseph Smith were roughly estimated about $73,000. What did he have in assets? Inventory of the property, approximately 20,000. So you could say he was well in debt. And this is the debts then that Emma, his wife, would have inherited after his death. Now, this is regarding Joseph Smith's death. Sir, at the last June term in Circuit Court, a judgment was rendered in favor of the United States against Joseph Smith, Hiram Smith, Peter Hawes, Henry and George Miller upon a note given by them 1st September 1840. The defendants in suit are Mormons residing in the state. defend Joseph Smith, is the prophet and leader of the sect, and unless the judgment can be collected of him, his brother Joseph Smith will be lost, as the other defendants are all insolvent. Joseph and Hiram Smith are now both applicants for the Bankruptcy Act, and the day for their final discharge is on the first day of October next, as you will perceive by their notices published on the last day of Sangamo Journal, 15th July 1842, which is enclosed. So Justice Butterfield, they were trying to prevent Joseph Smith getting a bankruptcy notice. And then because of John C. Bennett's publishing of letters, which contains second page, he charges Joseph Smith with the most gross fraud in disposing of cloaking and secreting property to a large amount for the benefit of himself and family in order to obtain the benefit of the Bankruptcy Act. So because of the allegations of John C. Bennett, they the, the letter from Justin Butterfield to Charles Penrose, they dismissed Joseph Smith's bankruptcy order, even though he was genuinely in bankruptcy. Now, we'll see that Emma was supposedly registering deeds on the 8th of July 1844, even though she was pregnant, a widow, and would have had great difficulty getting to Cartridge to register these deeds. And there's further documents about the deeds from Orson and Marinda Johnson that was deeded, that Joseph Smith, as trustee and trust, would have deeded to the Johnson, to the Hyde family, Orson and Marinda Hyde. He deeded to, okay, this is a bond from Smith Tuttle and John Gillett. Know all men that these present that we, Smith Tuttle of County of New Haven and John Gillett of the County of Logan, and held it firmly bound on Joseph Smith, sole trustee and trust for the Church of Jesus Christ of Latter-day Saints. So these documents were signed and recorded after Joseph Smith's death. And then the original deed, 7th of July 1843. As we showed above there, that was from the 8th of July 1844, when Joseph is dead. And then you have the deed 7th of July 1843, which was the original deed to Smith Tuttle and John Gillett. Another mortgage of 11th of July 1843. It's another deed that Emma never had and would not be able to send these deeds to Cartridge on the 8th of July or the 11th of July, 8th of July 1844. Sorry, the original being the 11th of July 1843. It gets confusing because they're trying to represent um, that Joseph Smith was deeding these things to Emma. Uh, so the deeds then would have been submitted, as I say, 8th of July 1844, when Joseph had died, and because William Clayton had the right to transact Joseph Smith's deeds and property, um, it still went on after his death. Whether it was mortgages and the 11th of July 1843 for William Law, I hereby assign into the hand of Joseph Smith all my right, title, and claim to this mortgage with interest thereon. Henry Buckwater. So what do we find? Am I trying to get at in these episodes? What do we find in these 34 land deeds which make up all deeds to women without a husband listed between 1842 and 27th of June 1844 when Joseph died? Deeds to Emma Smith and others. The unencumbered lot, which was as we say, they were not with debts. $10,000, 13th to June, deed to Mary Fielding, 15th to March 1843. So why, as I say, all of these transactions that we're talking about, these deeds to Emma and to Mary Fielding Smith? Let's go to the Nauvoo Relief Society Minute Book. 9th of June 1842. President Smith then said that he would give a lot of the land to the society by deeding it to the treasurer, that the society may build houses for the poor. So that's the real intention, the real focus I'm trying to get at here is it wasn't to persuade Emma Smith from not divorcing her husband, but to give to the Relief Society, of which Emma was president, to give to build houses for the poor and give property. And then, deed to Emma, 13th of June 1842, she is, we'll see here, deeding it out to others. Joseph Smith, as we'll see here, sole trustee and trust, deeding out to Mary Smith, would be another Mary Smith, probably Mary Fielding Smith, for the purpose of giving it to the poor. So what do we find in these 34 land deeds which make up all the deeds to women without a husband listed between 1842 and 1844 when Joseph died? Deed to Sarah Ann Whitney. They make out these particular, now this is based on the alleged polygamist narrative that they think that because these women were plural wives, they, he deeded to Elizabeth Durfee, Sessions, Rolling Lightner, Kimball, Lyon, Woodward, Mulholland, Partridge, Hyde, and Whitney. Um, you know, deeded it over to them because they were plural wives. $50 deed to a 14-year-old. Suggested wives. So apparent now look at that chart of all those deeds to the alleged plural wives, which are the red ones. As we say there, these 14 up here now are in red down here. So if, as I say, the red are in deeds, and if these, based on some of these historians who have alleged up to about 50 wives that Joseph Smith took, why didn't he give to these other women like Flanny Elger, Bedeman, Coolbridge, and all these other? Why not uh, give it to some of these others when they're apparently plural wives? Sarah Foster is another one that Joseph Smith, as trustee in the trust, gave to gave a property to, but um, she wasn't a plural wife. Grantors giving Robert Foster and his wife given back to Joseph Smith for whatever reason. The property was maybe given back to the church, which then Joseph Smith, as trustee in trust, would have given it out to another member. So if we see here the supposed wife, Sylvia Lyne, supposed marriage date, 1842 or 1843, but the date of the deed is 1840, 40 or 43. Mary or Patty Bartlett Sessions, 3rd of September 1842, but the date of the deed is 8th of September 1843. The dates do not add up. Sarah Ann Whitney, supposed marriage 27th of July 1842, but the deed is given what's that, the 6th of September or the 9th, because the American dating is probably the 6th of September 1842. So the dates do not line up between these supposed marriages and the dates of the deeds. There was, uh, if, as the narrative is, the false narrative that the plural wives were given deeds, the dates do not add up. We have women as grantors, Pergamon, Sessions, and Julianne, given to other women, Sylvia Lyons, Joseph Smith, trustee and trust given to Sylvia Lyons, um, Eaton Kimball given to Marinda Hyde. So it grantor Joseph Smith and Emma wife to Martha Knight, grantor William Blackhurst and Margaret wife, given actually to the children of Joseph and Emma. Now we see Joseph Smith trustee and trust given to the Partridges and others there. Joseph, here's an example. It wasn't just a case of Joseph Smith deeding to women or these supposed alleged wives. Joseph Smith as trustee and trust given to George Taylor, Joseph Taylor, the Taylor family. Newell K. Whitney deeding it to a family there, Melinda Lyman and Francis Lyman. Uh, Marriage certificate of Joseph Kingsbury and Sarah Ann Whitney, 29th of April, 1843. And the case there, I have upon this day joined together in marriage Joseph Kingsbury and Sarah Ann Whitney, the city of Nauvoo. This is the same Sarah Ann Whitney that was meant to have been a polygamous wife of Joseph Smith. So clearly false. Joseph Smith given to another family, John Woodward. Deeds given to daughters 7 and 4-year-old. Common basis not unique to women being expected to bring a dowry to their marriage. Dowry was common in England at the time. No dowry means less marriage prospects, less desirable to attract a mate. Therefore, the couple may not equally be matched to, say, the husband who has land or property. So the idea of the given properties to these young children and daughters was for the purpose of dowry. Um, so when we're seeing these given to daughters of William Smith, there's dowries that comes into it. Do you see there the daughter, um, Meriwether, daughter of Jacob Scott. Jacob Scott given his daughter Anne Scott a dowry, $300 there in that consideration. So there's many reasons why transactions going on. Joseph given to the Relief Society property. Joseph given it to member families, male, female, to children as dowries, to as trustee in trust of the church. Women given to women, husband to wife, given it to a woman there, Louisa Singer for $800. So there's all of these transactions going on. There's much others that could be said about how like just finishing up with this last example, to say that Brigham Young, who was obviously declared a polygamist and self-practicing, self-professed polygamist, but he granted land or a deed to Suzanne Burnell, $500, 14th of February 1842, but he never married Susanna Brunel, even though he was, you know, a polygamist for sure. And there we have another example of other. Heber C. Kimball never married Margaret Simpson, yet there is a deed for this happening. So these things would have happened. William Clayton never married Elizabeth Coleridge, yet a deed is recorded. So you see there, 27th of March, 1844, $325. So you can see there how several transactions of things going on, um, deeds being transacted and given over to granted to other people. They didn't marry them. Even Brigham Young and Heber C. Kimball, William Clayton, who were polygamists, gave over land and deeds to women, but they didn't marry them. It's not on record for them married them. And though Joseph Smith gave to these single widows or orphans, or didn't mean he married them. As we see, Emma Smith shared out those lots to as part of the Relief Society to members of the ward. So there's much going on here, and I thought in this episode it'd be valuable to share why we should address the fact that Joseph giving out deeds to women does not mean he married them or proved that he married them. It has no such a thing. And I still maintain confidently Joseph Smith, as a prophet of God, practiced monogamy, condemned polygamy all his life. And these actions that happened with deeds was to protect the church and the members. They had been through an awful situation, losing property, losing their lives in Missouri, all of that property and everything lost. And they wanted to safeguard measures and the putting property into the church leader, the church organization, and that Joseph Smith, as trustee and trust of these transactions, would be able to more safely carry it out. Okay, that's it for today. So thank you for listening, and speak to you again soon. Bye for now.